The next case is R.L.F., father of D.A.M.F., a child versus the Department of Children and Families. You may begin, sir. Do you want to reserve any time?
3 minutes, please. Morning, Honors. Let me apologize. In reviewing and preparing for this, I realized I miscited a case in my initial brief. D.D. case was cited as being page 614. It was actually page 615. I guess it was a typographical error. I believe the primary issue here, Your Honors, is that the Department failed to present substantial competent evidence in that they presented no evidence that the children suffered any physical, mental injury as a result of witnessing any altercation. The only evidence seems to be that the children or child may have seen something from inside a vehicle when the vehicle pulled into a driveway, but the children were not put on the stand. Their reaction to the situation was not presented by the department.
Counsel, isn't that something for the trial judge to weigh and decide? I mean, you could say that there's no evidence, but it's really, to me, it's a situation where the trial judge is weighing the evidence and concluded the opposite from what you concluded.
But there was no evidence at all presented on that issue.
Well, the child was in the back seat of the car.
Right.
And conceivably could have seen what was going on with the mother and father. And the rear door of the car was open. The rear door of the car was open, I think was testimony.
Correct. But from
all of that, why couldn't the trial judge conclude that there was a view of what was going on by the child?
I think the cases that I have reviewed indicate that there must be something more than a speculation that they might have seen it or might have been affected by it. This court's decision, I believe it was in, I apologize.
Yeah, but what if you heard the evidence and testimony and came to the conclusion that the child saw it based on the facts that, Judge Boyce just elicited? And that's not speculation, that's a fact finding, isn't it?
But what is speculation is whether the child was in any way affected. And no one testified about any effect at all on the child.
Is that necessary?
Yes, I believe it is.
Under what case?
I believe in this court's case of, in fact, D.D., the one I miscited, presence of the child must be something more than just physical proximity.
The presence is one.
Correct.
You were talking about the effect.
There must be some evidence. And now I'm citing to a more recent case. It was from September of this year, KB versus Department of Children and Families, the 937 2nd 709, which cites both the D.D. case and this court's W.T. case. It says there must be some evidence that the child sees or is aware of the violence occurring. Further, for harm resulting from witnessing domestic violence to constitute abuse. The domestic violence witnessed by the child must result in some physical, mental, or sexual injury to the child.
Does it take an expert to substantiate the fact that if a child sees his mother being beaten up by his father, that doesn't have any effect? Or does have an effect on a child's mental state?
Well, that was the other problem that I saw from the evidence. The court said he believed the Peelers, but one, Mrs. Peeler, testified that, in fact, before any altercation occurred between appellant and the mother, the argument had actually moved indoors. But there was no testimony that the children had come indoors. So, in fact, Mrs. Peeler's testimony was that the children would not have witnessed an altercation with appellant. Apparently, with the other lady who was there, yes, they may have witnessed that. Now, according to Mr. Peeler, of course, he said that the altercation happened outside.
The trial judge didn't believe that.
But we don't know that. He just says he believes the Peelers. the court unfortunately does not explain that to us, whether he believed in particular at that point in time, he believes
The trial judge isn't under an obligation to explain every single fact as he saw it in the trial to justify his conclusion. And the trial judge sitting there listening to this, he evaluates it, comes up with a conclusion, it seems to me. Well, he don't have to explain that.
But I think
there's evidence to support it.
I think he does have to articulate what evidence he's basing the effect on the child on. And I don't believe that was articulated at all in the court's ruling. In fact, the case I was just citing...
But you got a case that says he's got to articulate, I mean, if there's evidence in the record, testimony that would support the obvious conclusion he made, I mean, he had to make that conclusion to come to the result he did. Have you got any case that says that he must articulate it?
In a roundabout way, yes, the case I was just citing, because what they found was that there was evidence actually presented that the children were upset by an argument, that in fact the children were crying and screaming when the altercation was occurring, and that one of the children was upset for a short time afterward, but the department presented no evidence that the children suffered any physical or mental injury as a result of witnessing it. In other words, as in this case, the department did present evidence that an altercation occurred and that children might have seen that altercation.
That doesn't go to the issue that I raised in my question, though, whether the trial judge has the obligation to articulate what facts he finds or what reasons that he finds to justify his decision.
But I think there must have been some evidence presented to him on that issue, and here there wasn't any.
Okay. That's why we're up here, I guess. We have to look at the record and decide whether there's evidence or not.
And the other way of showing this, I believe, is that they must show that the parent poses a present threat at that moment. Well, that also was not shown. It was shown that, yes, there had been a fight, and it may have escalated into a physical fight between the parents, but it didn't show that the children themselves were directly affected. This own court's decisions, since the filing of the briefs in this case...
Are you advocating a rule that we would adopt that says that if you got to prove respectively, you got to have an expert witness come in and testify as to the effect of the children?
No, I don't believe that is necessary.
Then how would you ever prove it?
I think it's a matter of reasonableness. As this court has found, situations where there were extreme arguments. There was one, I believe, involving the woman being attacked with a hammer and her skull being split. Obviously, the children were going to be adversely affected in that type of circumstance. Situations where there's a repeated pattern of abuse, which was not presented in this case, and where it's shown that these occur in the home and that the children are regularly present. Another case where the imminent danger was shown because the father was a drug dealer who did numerous drug deals in the home while the children were present, and firearms were left where the children could get to them.
Obviously, in all of these cases, you have different factual scenarios, but I'm trying to carve out in my own mind how you would adopt a rule that would do what you're trying to do, and that is to say that in order to have proof of prospective abuse, you've got to have something more than just testimony about the child seeing it.
I think it's what the child sees and how severe it is that the child sees.
But isn't that the severity of it the trial judge's domain again, weigh?
I don't think so, no. I think weighing who he finds to be telling the truth maybe, but I think the reasonableness of it.
Well, you would agree that the trial judge is there. I mean, if you got a simple situation where the husband grabs the wife and maybe shakes her versus a situation where they get into a fist fight and the husband is punching her, certainly the trial judge has to take all that into consideration in weighing whether or not there's prospective abuse, right?
Certainly. I think the other proof problem, though, in this case was a lack of physical evidence how severe this particular fight was,
I'm just rereading the trial judge's order, and it's chock full of how severe this fight was. And he concludes by saying the evidence is clear that the father was physically violent with the mother in incidences when the child and other children were actually present. His actions could reasonably result in serious injury to the child. The evidence is also clear the mother was physically violent. I mean, these two people fought, sounds like, pretty seriously in front of this child. I mean, that's in the order. So, I mean, I hear what you're saying, but the order clearly articulates the things that the trial judge saw that caused him to terminate that relationship. So.
But I don't believe that is actually backed up by the record. I don't believe that the testimony in the case backs up that there was that severe a fight between the father and the mother.
Miss Peeler says that the father took the mother's head and slammed it into the back of the car. I mean, frankly, I think that's relatively rough. I mean, that was Miss Peeler's testimony.
Right. Was it Mr. Peeler or Mrs. Peeler?
I think it was Mrs. Peeler. I may have it confused. My memory may be fading, but I'm old.
But I think there again, we don't know whether or not the child saw that or not.
Well, child's in the back seat with two other children, the door's open, and the husband slamming the wife's head into the back of the car. I mean, there's a reasonable inference that can be made from that.
But the other part of it that has bothered me since the Peelers claim that this happened is why there are no police reports that this actually happened.
Well, Mama got a 2-year probationary sentence. I guess there was some police reports.
That was the mother in an earlier incident, and we're not disputing that the mother at that particular point in time who needed medication didn't commit that offense and in truth almost caused an automobile accident because of the fight that was going on. It's conceded that she had some severe mental problems, and that
she's bipolar.
Yeah, that and I believe there were some other issues also. So there were some depression issues. And
Dr. Kropp says that your client has I forgot what personality he has, but it was not a good one, whichever it is.
But he also was guarded in his opinion because he conceded, Dr. Kropp conceded that he was not informed that my client had in fact gone through therapy. He also conceded that a good portion of his initial opinion was based on my client's ex-wife's fears during, or her assertions, which he had no way of confirming whether they were true or not.
Counsel, you're asking us to reweigh testimony. I mean, the trial judge conceivably could have just totally ignored that evidence, and there would be no way we could know whether what you're saying is accurate or not. It's the trial judge's role, not ours.
Well, I believe as to Dr. Kropp's testimony, he should not have admitted it, and Dr. Kropp himself said that in any opinion he would give now, he was guarded in giving it because of the changes in circumstances and the fact that several years had passed.
But the trial judge takes all of that into account, presumably.
I don't know that the trial court did, because the trial court
You
just
can't guess that whether he did or didn't. So, I mean, you're asking us to perform a function that it's not for the appellate court to perform.
No, I'm asking you to rule that Dr. Kropp's testimony should not have been admitted. And in fact, what the trial court did here was it said, okay, I'm going to believe this portion of Dr. Kropp's testimony, but say he's not a competent expert when he's saying any opinion I would really give at this point in time would be guarded because I don't have sufficient information. And that's, in a sense, what the trial court had to do, was carve up Dr. Kropp's own opinion to suit the court's ruling. And I don't know how the court can do that and say this man's an expert, but I'm going to discount his own.
He can do it because he's the trial judge and aware of facts, and he can believe some of it and disbelieve others. He can give certain weight to portions of the testimony and less weight to others. That's how he does it. I mean, that's done all the time by trial judges.
I understand that.
What we tell juries they're supposed to do.
But
what juries do as well.
But in this instance, where Dr. Kropp's testimony was from an evaluation done several years earlier and before R.F. had gone through counseling, I believe that testimony was irrelevant.
But the trial judge heard all of that. The trial judge may not have felt it was irrelevant. Maybe he felt it was irrelevant and it didn't enter into his decision. We don't know that, and as an appellate court, we can't start guessing at what the trial judge may or may not have concluded based on certain testimony that was given.
I believe the appellate court can decide whether or not the trial court was correct as to the relevancy of the testimony or of an old report. All of the cases, in fact, cited by appellee as to the trial court deciding to believe one expert or another were all recent evaluations. But in this case, it was an evaluation that was almost 5 years old, and several things had occurred since then. I think this court can decide whether or not the trial court was correct in admitting the evidence on relevancy.
Thank you, counsel. You got about 4 minutes. You want to reserve any time left? You said 3 minutes initially.
I'll reserve the rest. Thank you.
Thank you. Mr. McMurphy, we're sorry to see you in that restraint.
Well,
I'm sure it wasn't.
Quite a fashion statement there, Mr. Miller.
I'm Ralph McMurphy for the Department of Children and Families. I ended up telling a joke on myself to my secretary. I have a metal plate in my neck that's held in by 2 screws, and my doctor just found out last week that the screws are broken. So I told my secretary I have some loose screws, and she said, I've known that for years.
You're still a pretty good lawyer, though.
But
There may be a cause and effect right there.
I think the court has hit on the real crux of this case. It turns on the credibility of the evidence and who the witnesses, the trial court, believed and accepted their testimony. And if you look at the order, the trial court makes some very explicit findings, including that there was this child and Ms. Peeler's 2 children were in the back seat of the car. There was also the incident where the wife tried to stab the father with a screwdriver that occurred in the car with the 3 children in the back seat, one a very young infant. But I think what R.L.F has missed in this case is that the trial court didn't find that she had actually been abused in the past, but that if the situation was not corrected, she was at substantial risk of imminent harm. And it doesn't take an expert to come in and testify about the harm that domestic violence can do to children.
Do you know of any cases that say that we must have testimony concerning the harmful effect on the child?
No, Your Honor. In fact, this court recently decided Moorcroft, and I forget the name of the, but it was a Moorcroft case out of Orange County, I believe, where the court specifically said that expert testimony is not required. And then in the 3rd District, in an opinion, went on at length, pointing out all of the studies and all. And this court pointed out in an earlier case that the American Bar Association and the Florida Bar and all have recognized that domestic violence is a serious problem that can affect children.
Does the trial court have to make specific findings as to the impact on the child witnessing the violence, or is that something that we just glean from the evidence and testimony ourselves?
Well, I think that it should not, you don't have to have an expert.
Yeah, no, we don't have to, but does the trial court have to make specific findings that I find that the child was impacted or suffered from witnessing
Well, in this case, the trial court found that the child was at imminent risk. The trial court did not find that she had actually been abused in the past, but that she was, because of the violence that the trial court found, that she was at risk in the future for harm resulting from this violence if it was not corrected. And that's the whole purpose of dependency, is to correct the situation. And the trial court's findings of fact are pretty explicit and about who the trial court believed and the testimony the trial court believed, including the trial court's findings with regard to Dr. Kropp's testimony. And from that, the trial court determined that there was a nexus between the past events and to show that they can be predictive of the future events.
Well, his specific finding was there's an ample nexus between the parents' disorders and the substantial risk of danger to death to the child.
Yes, Your Honor. The trial court's order is very explicit.
I think the trial court did make findings of fact that support the conclusion anyway, and I think that it's set forth in the order.
Yes, Your Honor.
Thank you.
The Moorcroft decision that was cited by my friend opponent, that is in fact the case where, I believe it's now cited at 935 Southern 2nd 538. That's the case where apparently the father attacked the mother with a hammer, split her head open, cracking her skull, causing her to be hospitalized and the children to go into shelter. And there, what this court said was that the attack was so horrific that no expert testimony would be necessary. But in almost every other instance, there is some evidence that proving that, or showing at least that the children did in fact see it, and that there was some effect on the children, either through their testimony or testimony of some expert that has had contact with the children afterward. And what is totally missing in this particular case is any evidence verifying that the children in fact saw the incident, and in any way indicating what their reaction to the incident was, or even the prior incident. In the prior incident where the mother was attacking the appellant, he immediately called the authorities for help because he knew something was going horribly wrong with her and wanted assistance getting her to some mental health facility. Because he couldn't figure out why she was doing what she was doing. But in the incident at the Peeler's home, we have no indication as to what effect it did or didn't have on either the child in this particular case or the Peeler's children, who were older, who could have testified as to what they saw and what their reaction was. But we don't have any of that. And I believe that because the department failed to present any of that evidence, that the trial court was in fact inserting evidence that wasn't even there in order to come to the conclusion and the findings that it did. Thank you.
Thank you, counsel.